Picture one of the most famously meticulous, controlling artists in the entire history of modern music. I mean, we are talking about Prince,
Right.
a man who literally changed his name to an unpronounceable symbol,
Yeah.
just to escape a restrictive record contract with Warner Bros.
Yeah, that was a huge deal.
It was. He fought this brutal, incredibly public war for total creative control over his master recordings, his personal brand. He even appeared with the word slave written on his cheek.
I remember that, yeah. To protest the industry construct.
Exactly. So now take that exact same genius, right? A towering figure of artistic autonomy, and picture him dying with a $156 million empire and leaving behind absolutely zero instructions for what should happen to it.
I mean, none. Not a single document.
None at all.
And, the paradox there is just striking. Because Prince spent his entire life engineering this unprecedented level of agency over his output.
Right.
He owned his masters. He built his own production compound at Paisley Park. He controlled his distribution.
Yeah, he controlled everything.
Yeah, but then, in death, he left behind this complete vacuum of agency. I mean, he basically allowed the very systems he fought against his entire life to just step in and manage his legacy.
And that paradox, that is the core of our mission for this deep dive today. We're unpacking a stack of sources, primarily these really fascinating excerpts from a legal analysis show called The Will Room.
Which is a great breakdown of the whole situation.
It really is. They dissect the entire breakdown of Prince's estate. So we are going to look at the legal, the financial, and the deeply personal fallout when a legacy of that magnitude is just, well, abandoned to the default rules of the state.
Yeah, because there's so much to learn from this.
Exactly. We're examining what you, the listener, can actually learn from a 9-figure mistake. And to frame this, before we really dive into the mechanics of it all, it's kind of like spending your entire life building this high-tech, impenetrable fortress to protect all your treasures.
Right. You install the biometric scanners, the titanium walls.
The laser grids, all of it. But then when you finally leave the building for good, you just leave the front door wide open. You prop it open with a cinder block and, I don't know, you light up a neon sign pointing right inside.
That fortress analogy holds up so well, especially when you consider the sheer volume of intellectual and physical property that was just housed inside Paisley Park.
Oh, absolutely.
The open door, in your analogy, that represents the absence of a documented transition.
Right.
Because the legal reality is that without a will, the fortress has no designated guardian. So the state simply assumes control of the perimeter and just starts letting people in based on this arbitrary biological checklist.
Wow. Okay, so let's anchor this in the timeline. It's April 2016. Prince is found dead at his Paisley Park estate in Minnesota. He was only 57.
Yeah, incredibly young.
And there was no public warning, right? No known long-term illness that the public was aware of. So the cultural shockwave was just massive.
It was everywhere.
But behind closed doors, the focus violently shifted from mourning this cultural icon to sheer panic over the status of his business empire.
Right, because when attorneys and advisors rushed in, they were looking for a very specific type of paperwork.
And the fact that they found literally nothing is what kicked off this 6-year legal nightmare.
Yeah, and you have to understand, when dealing with ultra high net worth individuals, the baseline expectation is that there is this massive invisible architecture surrounding their wealth.
Like trusts and things like that.
Exactly. We aren't just talking about a simple document signed at a local law office. I mean, a celebrity of Prince's stature typically operates within a web of really complex estate planning structures.
Right.
You usually see revocable living trust to avoid probate entirely. Delaware LLCs specifically designed to hold certain intellectual property rights.
Layered privacy firewalls too, right?
Oh, absolutely. Privacy is huge. They want to ensure the public, and definitely the media, never see the inner workings of their finances or their personal relationships.
So his team went into his home, they went into his private safe, his business files at Paisley Park, fully expecting to find the blueprints to this architecture.
Yeah, the operating agreements, the master trust documents.
And they found heir. Just not a single valid will or trust document existed anywhere.
Which is just staggering.
It really forces us to look at the sheer scope of what was suddenly left totally unprotected. I mean, we aren't just talking about a healthy stock portfolio here.
No, not at all. You have Paisley Park itself, which is this 65,000 square foot compound.
Right. And one of the most lucrative music catalogs in existence, just generating continuous royalty income.
And then, perhaps the most famously, there's an actual physical vault.
The vault?
Yes, containing thousands of hours of unreleased master tapes, music videos, and just raw artistic concepts.
The vault is honestly the most unique asset in this entire scenario. I mean, it was literally a climate-controlled bank vault in the basement of Paisley Park.
Right. You have physical master tapes that had never seen the light of day, and they were entirely at the mercy of this legal void.
But, the failure to protect these assets wasn't just some casual oversight. I mean, it requires a very specific kind of avoidance to reach the age of 57 with a whole team of lawyers and financial advisors at your disposal and actively refuse to sign a single estate planning document.
It really does. It's a psychological thing.
Yeah, and I really want to push back on the psychology of that avoidance for a second. Why would someone who was so detail-oriented that he literally oversaw the exact lighting cues of his live shows completely ignore the fate of his own catalog?
Great question.
Is it a symptom of celebrity isolation? Like, you have access to the best healthcare, you are surrounded by people who just cater to your every whim, so you develop this illusion of invincibility?
Yeah, I think that's part of it.
Or is it just a fundamental human aversion to confronting mortality, but scaled up to $156 million?
I mean, I think it is a collision of both of those factors, honestly. Yeah. The psychology of extreme success often generates this sense of indefinite momentum. When a person is constantly creating, constantly directing their environment, um, death basically represents the ultimate unacceptable loss of control.
Wow, right. It's the one thing you can't manage.
Exactly. So for highly controlling individuals, avoiding the paperwork of death is almost a subconscious way of rejecting the reality of death.
Which is just so tragic when you look at the outcome.
It is. The tragic irony is that by refusing to contemplate the end, Prince guaranteed the absolute loss of control over everything he had so painstakingly built.
Right. He controlled the studio down to the decibel, but he completely failed to dictate who actually held the keys to the studio the moment he was gone.
Exactly. And because he didn't dictate it, the law stepped in.
Right, and the sources zero in on this massive legal concept here, dying intestate.
Intestate, yeah.
Which is the formal legal term for passing away without a valid will. And when that happens, the jurisdiction, so in this case, the state of Minnesota, completely takes over the entire process.
Yeah. And, intestacy laws are basically designed as an emergency fallback system.
Like a safety net.
Right, but a very rigid one. The state legislature essentially creates a generic default will for anyone who just didn't bother to write their own.
Okay.
And this default mechanism is a fixed, highly rigid formula based entirely on something called the table of consanguinity.
The table of consanguinity. That sounds so clinical.
It is. It's a strict biological and legal family tree.
So basically, if you don't write your own ending, the state writes it for you using this bureaucratic Mad Libs template, and they do not care if it ruins the story you spent decades writing.
They don't care at all. The formula is completely blind.
It doesn't factor in Prince's philanthropic causes, right?
Yeah.
Or his favorite charities, or all those trusted creative collaborators who arguably understood his artistic vision better than anyone else.
No, the state's algorithm is entirely indifferent to the nuances of human relationships.
It's just math.
Just math. It does not measure affection. It doesn't measure competence or artistic alignment. It literally only measures biological proximity.
So how does it actually work? Who gets picked first?
Well, the formula typically looks for a spouse first.
Okay.
If there is no spouse, it moves down to descendants, so children.
Right.
If there are no descendants, it moves up to parents. If the parents are deceased, it moves laterally to siblings. It is just a cold mathematical march down the bloodline.
Which brings in this huge issue of personal estrangements. I mean, you could absolutely loathe a family member.
Oh, happens all the time.
You could have legally battled them in life or literally not spoken to them in 30 years. But if the state's math points to them, they inherit, period.
That is the complete erasure of agency that really defines intestacy.
Wow.
Yeah, the probate court isn't some detective agency tasked with uncovering your secret desires.
Yeah.
They weren't reading your personal diaries to figure out who you really love.
They just look at the chart.
Right. The judge's only mandate is to execute the algorithm laid out in the state statutes.
Okay, so let's trace how that algorithm actually played out for Prince in the spring of 2016, because our sources note he had no surviving spouse.
Right.
He had been married twice, but both of those marriages ended in divorce.
Right.
And he had one child who tragically passed away shortly after birth, so he had no legally recognized living descendants.
Right. And both of his parents had already passed away by that point as well.
So the algorithmic spotlight just violently swings over to the next branch, which is his siblings.
Yes. And this is where a $156 million valuation turns what would be a standard legal procedure into an absolute circus.
A circus is the right word for it.
A combination of a massive liquid fortune, a globally recognized name, and literally a blank slate of inheritance.
Hmm.
It creates this massive gravitational pull for fraudulent claims.
The sources detail how dozens of people just flooded the court system over the next several months. I mean, claimants were coming out of the woodwork across the entire country.
Yeah, people claiming to be biological children from secret affairs, unknown siblings, even unrecorded wives.
It's wild. There was even this one inmate in a high-security federal prison in Colorado who filed paperwork claiming to be Prince's biological son.
Yes.
He was insisting his mother had met Prince at some hotel in the late 90s.
Which, to understand how the justice system even manages this kind of siege, you have to look at the role of the special administrator.
Okay, because the judge can't deal with all that.
Exactly. The probate judge cannot personally investigate 50 different claims of paternity. So the court appoints a neutral third-party entity.
And in Prince's case, that was Comerica Bank and Trust.
Right. Comerica Bank and Trust. They were empowered to manage the estate's ongoing business, which, by the way, is incredibly complex when you're dealing with global music royalties.
Oh, I can't even imagine.
And simultaneously, they had to clear the brush of all these fraudulent claims.
But how does an institution like Comerica even begin to process that volume of claims? Like, an inmate files a motion from Colorado, someone in Florida claims a secret marriage. They can't just throw the letters in the trash, can they?
No, they absolutely cannot. They have to legally respond.
They have to formally respond to every single one.
Every single one. They have to formally evaluate and dismiss each one because under intestacy law, the court is actively looking for the rightful heirs. They have a duty to find them.
So what's the tool for that?
The primary tool Comerica had to use to cut through all this noise was methodical genetic testing.
DNA.
Right. The administrator established strict protocols, basically requiring claimants to submit to DNA testing under these highly controlled, court-monitored conditions.
I mean, I imagine the administrative bleed starts right here, right? Because the cost of a DNA swab is cheap. You can get that at the pharmacy.
Yeah.
But the legal apparatus surrounding it is definitely not.
Oh, it's incredibly expensive.
You have lawyers reading the initial claim, then drafting a formal response, then petitioning the court for a testing order, managing the chain of custody for the DNA so it's admissible, analyzing the lab results, and finally presenting a motion to dismiss to the judge over and over again for dozens of people.
Yes. The financial drain is just immense, but it is legally mandated.
Right.
The administrator has a fiduciary duty to ensure the estate goes to the correct people under the law.
Yeah.
And they did. They successfully, methodically ruled out the vast majority of these fringe claims for a total lack of genetic evidence.
So ultimately, the testing and the documentation narrowed the field down to just 6 legitimate heirs,
Right.
1 full sister, Tyka Nelson, and 5 half-siblings from his father's other relationships.
Exactly.
But I have to challenge this setup, though, just for the listener who might be feeling a little cynical about the legal system right now. Even if Prince had drafted an ironclad will, leaving his entire estate to, say, a specific music charity, wouldn't a $156 million fortune attract fake sons and secret wives anyway? I mean,
Yes.
people see a 9-figure payout, they're going to file lawsuits, regardless of what a piece of paper says, right?
Well, they might try to file a lawsuit, sure. But the trajectory of that lawsuit is fundamentally different when a will actually exists.
How so?
A legally executed will acts as a fortress wall. It provides what we call in law standing.
Standing, okay.
Yes. If a will exists that leaves everything to a charity, a random claimant from Colorado doesn't just get to enter a blank slate inheritance pool and say, hey, prove I'm not his son.
Oh, I see.
They first have to prove that the existing will is invalid.
They have to break the document before they can even get to the money.
Precisely. They have to prove the testator, in this case Prince, was heavily coerced or was suffering from severe mental incapacity when he signed the document.
And for a highly functional, globally touring artist who's surrounded by legal counsel all the time, proving incapacity is practically impossible.
It's a near impossible burden of proof. A will shifts the burden of proof entirely onto the attacker.
Ah.
But with intestacy, there is no wall. The state's door is just propped wide open, and the court is forced to entertain and investigate claims that a standard will would have just dismissed right at the threshold.
So the will is essentially the bouncer at the door.
That's a great way to put it.
And without it, anyone can just walk in and demand the court verify their DNA. Okay, so the genetic testing finally concludes. The bouncer identifies the 6 true heirs. You'd assume the hard part is over, right?
You would think.
But our sources highlight that determining who inherits was merely the prologue.
Yeah, unfortunately.
Determining what they inherit, and crucially, what that inheritance was actually worth, triggered an absolute war with the Internal Revenue Service.
Yeah, and this is where the intricacies of high net worth estate law
Hmm.
truly materialize in a scary way.
Yeah.
The estate's own valuation team, so these are experts hired by Comerica to appraise every single asset. They conducted a massive audit.
Right.
They looked at the real estate, they looked at the current royalty streams, and of course the unreleased material in the vault.
The famous vault.
Right. And they applied standard appraisal models and concluded the estate had a fair market value of roughly $82 million.
$82 million, which is a massive sum.
That's huge.
But the IRS looks at the exact same assets, the same vault, the same real estate, and completely rejects that number.
Completely.
They counter with a valuation of over $163 million. I mean, that is a 100% difference.
It's wild.
We aren't just looking at a slight disagreement over real estate comparables in the neighborhood. We're looking at an $81 million gap in perceived value. How is a discrepancy of that magnitude even legally possible?
Well,
I mean, it sounds like you're trying to put a definitive price tag on a painting that is still locked in a dark room, and you are arguing with the federal government over how much the public might pay to see it in a decade.
yes. Your analogy points directly to the underlying friction in valuing intellectual property.
Because it's so subjective.
Exactly. How does the government tax potential? Because if a person dies with a stock portfolio, the valuation is totally objective, right? The market dictates the exact price per share at the close of trading on their date of death.
Right, you just look it up.
Exactly.
Yeah.
Real estate is valued based on recent sales of comparable properties in the same zip code. But there are no comparables for a vault of unreleased music by a generational genius.
No.
It is an unprecedented asset class.
And the music hasn't been mixed, it hasn't been mastered, it hasn't been marketed. You literally don't know if the fans will consider it a masterpiece or just a collection of unfinished demos.
Right, and that's the core of the estate's argument. The valuation was likely grounded in traditional discounted cash flow models.
Meaning what, exactly?
Yeah, they would look at the tangible reality. So the immense multi-million-dollar cost of restoring, producing, and actually marketing that unreleased material, combined with the very real risk that it might just not sell.
Okay, that makes sense.
So their $82 million figure represented a very conservative estimate of present value. But the IRS, however, utilizes a hypothetical willing buyer and willing seller standard.
Oh, boy.
Yeah. They looked at the sheer cultural frenzy following his death, the massive spike in streaming numbers, and the theoretical maximum market capitalization of the entire Prince brand.
The government essentially priced in the hype.
They absolutely priced in the hype.
But wait, if the IRS taxes the estate based on this aggressive potential value, right, and then the estate fails to actually generate that money, say, the posthumous albums just completely flop, does the IRS issue a refund for overtaxation?
They absolutely do not.
Wow.
Yeah, the tax is assessed based on the theoretical value at the time of death, completely regardless of subsequent market performance.
That feels so unfair.
And it gets worse. The sources reveal a particularly aggressive tactic by the IRS in this specific case.
What did they do?
The agency didn't just disagree with the $82 million valuation. They proposed an accuracy-related penalty on top of it.
Wait, because they felt the estate intentionally lowballed the number?
Exactly. Under the tax code, if the government determines that an estate's valuation is a substantial undervaluation, they can actually levy a 20% penalty on the underpaid tax.
20%.
Yes. It is a massive pressure tactic.
Yeah.
The IRS was basically just signaling, hey, your number is so unreasonably low that we are going to fine you millions of dollars simply for submitting it in the first place.
Which just forces the estate's administrators into a highly defensive, heavily litigated posture.
Exactly. They have to fight it.
So Comerica Bank and the IRS are just locked in this high-stakes standoff, going back and forth for years, trading expert witnesses, negotiating the hypothetical market value of art that is literally still sitting on analog tapes in a basement in Minnesota.
Yeah. But ultimately, the risk of a protracted trial in tax court was just too great.
Because if they lose, the penalties would be catastrophic.
Right. So the estate and the IRS finally reached a settlement. They agreed on a final valuation of $156 million.
Which is remarkably close to the IRS's initial high-end demand of 163,
Very close.
which means the final estate tax bill was just staggering.
Oh, massive.
Because the federal estate tax rate for assets over the exemption limit is 40%.
Right.
And Minnesota also has a state-level estate tax that runs up to 16%. So when you combine those, more than half of that $156 million is instantly earmarked for the government.
Yeah. Half of it is just gone. But, that is the reality of the estate tax. But the tax bill itself is actually only one part of the financial destruction here.
Right, because of what the source is called the bleed.
Yes. The real tragedy of this case is the bleed.
The timeline on this is just sobering. Prince passed away in April 2016, but the final structure for the estate wasn't legally solidified until the summer of 2022.
Over 6 years.
Over 6 full years of administrative purgatory. And based on our sources, I have to raise a pretty cynical point here.
Go for it.
For the first 6 years following the death of one of the greatest artists of the century, the primary beneficiaries of his life's work were not his siblings,
No.
and they certainly were not his fans. The primary financial beneficiaries were the probate lawyers, the institutional administrators, the tax consultants, and the genetic testing labs.
It is entirely factual. I mean, the sources document that tens of millions of dollars were actively drained from the estate to simply feed the machinery required to resolve it.
Tens of millions.
Yes. The bleed is the silent killer of complex intestate estates.
So let's break down how that bleed actually functions in the real world, because it isn't a single invoice at the end of the process, right?
No, no.
It is the relentless drip of hourly billing over 72 months.
Exactly. Every single action requires highly compensated professionals. When that Colorado inmate files a claim, a team of lawyers bills hundreds of dollars an hour just to read and process it.
Right.
When Comerica negotiates with the IRS over the valuation of a master tape, you have specialized tax attorneys and entertainment industry appraisers billing for their time.
And PR firms too, right?
Oh, yeah. You have PR firms hired to manage the media fallout. You have music industry veterans brought in as consultants to advise the bank on how to handle the catalog.
It just never ends.
Every motion filed in probate court, every single hearing scheduled, drains cash reserves directly out of the estate before any heir receives a single dollar.
And none of these professionals are working on a contingency basis where they just take a cut of future posthumous album sales.
Oh, absolutely not.
They are submitting monthly invoices for cold, hard cash.
Exactly. And if the estate is tied up in illiquid assets, like real estate or unreleased music, the administrators might actually have to leverage or sell off assets just to generate the cash required to pay the legal fees and the IRS tax bill.
Wow.
The administrative state gets fed first.
Always.
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 Okay, so in 2022, the bleeding finally stops. The massive IRS bill is settled. The fake heirs have all been dismissed. The lawyers collect their final checks. What happens to the remaining assets? Who actually holds the keys to the fortress at the end of all this?
Well, the final structure is a pretty complex compromise. By the end of the process, several of the heirs had essentially cashed out.
Cashed out, like they sold their spots in line.
Basically, they sold their expected shares in the estate to a major music management and publishing company called Primary Wave Music.
So rather than 6 siblings trying to run a global music empire from their kitchen tables, a massive corporate entity steps in.
Right. Because managing a catalog of that magnitude, negotiating the licensing deals, and overseeing the vault, it requires massive infrastructure.
That makes sense. So the ultimate 2022 agreement resulted in a joint management structure. The estate was divided roughly in half between Primary Wave Music and a holding company representing the remaining heirs.
It is genuinely wild to step back and just look at that outcome.
It really is.
I mean, a man who famously wrote the word slave on his face, who changed his name to an unpronounceable symbol specifically to ensure absolute, uncompromising creative control over his art. Yeah. He ends his journey with his life's work being jointly managed by a corporate entity and a committee of half-siblings, an arrangement that was dictated entirely by a Minnesota state algorithm.
It is the defining irony of this entire legal saga. The fierce independent who fought the system basically lost his legacy to the system.
Which brings us to the core mission of our analysis today, which is translating the rock star to the listener.
Right, because this affects everyone.
Yes. The Will Room sources specifically highlight 3 definitive universal lessons from this case. And these aren't just warnings for billionaires.
No, not at all.
The mechanics of failure here scale down perfectly to the average person going to work every day.
They really do.
Yeah.
The legal principles of intestacy do not care if your estate is worth $156 million or $156,000. The exact same rules apply.
So let's walk through these lessons methodically. Lesson number 1 from the source material: state formulas overrule personal wishes.
This is the absolute bedrock warning of estate planning.
Okay.
If you not formally, legally document your intent, the default rules of your jurisdiction take complete control.
Right.
It does not matter what you told your best friend over drinks. It does not matter what you promised your partner of 20 years.
Or what your family all agreed on at Thanksgiving.
Exactly. It does not matter if everyone in your community implicitly knew what you wanted to happen.
If it is not legally executed on paper, your intent basically does not exist in the eyes of the law.
It doesn't exist.
Yeah.
The state formula is entirely blind. It will gladly prioritize a distant biological relative you haven't spoken to in a decade over a life partner you never legally married, or a charity you dedicated your entire life to supporting.
Because intestacy guarantees the erasure of your personal relationships in favor of rigid biological flowcharts.
Exactly that.
Okay, lesson number 2. Valuation planning is critical. Now, obviously, most of our listeners do not have a climate-controlled vault of unreleased, multi-platinum master recordings in their basement.
Probably not, no.
But how does this apply to the average complex asset?
Well, it applies to any asset that lacks a clear, publicly traded market value.
Like what?
Think of a small family business, a local restaurant, a plumbing company, or maybe a minority stake in a tech startup.
Oh, sure.
Or it applies to unique real estate, like a family farm or a cabin that has been passed down through generations.
Right. So if you leave behind a business and you haven't established a documented framework for how it should be valued or transitioned, you are just leaving behind a grenade for your family.
Precisely. If you do not define the valuation mechanism, the IRS or the state tax authorities will attempt to define it for you.
And they want the most money possible.
Exactly. They will invariably argue for the highest possible number to maximize tax revenue. Furthermore, without a valuation framework, the heirs themselves will fight over what the asset is worth.
Because one sibling wants to sell and the other wants to keep it.
Exactly. A sophisticated estate plan doesn't merely list who gets what. It establishes the legal mechanisms for how things are valued, often utilizing buy-sell agreements or specific trust language to avoid these costly disputes.
Which leads directly into the third universal lesson from our sources. Time and cost scale directly with the absence of a plan.
This is perhaps the most painful takeaway. 6 years and tens of millions of dollars in fees is not some freak anomaly for a contested high-value intestate estate.
It's not.
No. As the source material bluntly points out, it is the expected outcome of ambiguity.
It's the standard operating procedure for a mess.
Yes, conflict is expensive, and ambiguity breeds conflict. When there is no clear plan, everything is ambiguous.
So everyone fights over it.
Exactly.
Yeah.
Now, compare that to a properly drafted estate plan utilizing trusts. A structured plan generally resolves in a fraction of the time with a fraction of the cost.
Because the instructions are clear.
The instructions are clear, the assets are properly titled, and often the probate court is bypassed entirely.
Okay, I want to turn this directly to the listener right now with a highly practical question.
Sure.
If I am listening to this deep dive while driving or, walking the dog, and I don't own a music catalog,
Right.
but I do own a house, maybe a 401k, a standard savings account, and I have a couple of kids, what is the baseline documentation I actually need to ensure my family doesn't spend 6 years bleeding money to probate lawyers?
The baseline fortress is simpler than most people assume. It really just requires 3 fundamental pillars.
Okay, what are they?
First, a will. This is the foundational document that clearly directs your assets. And crucially, if you have minor children, it legally nominates their guardian.
Oh, wow. Because without a will, a judge decides who raises your kids based on who steps forward.
Exactly. It's left up to the court, so you need a will. Second, you must aggressively manage your beneficiary designations.
On accounts.
Right. Assets like 401ks, IRAs, and life insurance policies typically pass completely outside of the probate process. They go directly to whoever is named on the specific account form.
Now, this is a massive trap, isn't it? Because contract law overrides probate law here.
It absolutely does.
So if I named my ex-spouse on my life insurance policy 10 years ago and I forget to update it, the ex-spouse gets the payout, even if my brand new will explicitly says my current partner gets everything.
That happens constantly. Beneficiary designations on financial accounts operate totally independently of the will. You have to audit them regularly.
Note to self, check those accounts. Okay, what's the third pillar?
And third, you need powers of attorney, both financial and healthcare.
Right, for when you're still here.
Exactly. These documents are vital while you are still alive. They legally appoint someone to make medical or financial decisions on your behalf if you become incapacitated due to an accident or illness.
So those three things, a will, updated beneficiary designations, and powers of attorney, that builds a solid, highly effective legal fortress for the average person.
It does. It covers the bases.
It is about taking the pen and actively writing your own ending instead of just handing a blank Mad Libs page to the state legislature.
It is the ultimate exercise of personal responsibility.
To wrap up our deep dive today, the ultimate tragic irony of the Prince Estate saga is the question of resources.
Yeah.
This artist had unlimited financial resources. He had access to the most brilliant legal minds on the entire planet.
You could have hired anyone.
He had the ability to create the most sophisticated, customized, impenetrable estate plan in the country. He could have detailed exactly how his unreleased music should be mixed, who should profit from it, and exactly how his vault should be managed.
But because he actively refused to take that step, strangers stepped into the void.
Yeah.
Probate judges, state legislators, genetic testing laboratories, corporate executives, and the Internal Revenue Service ended up making all the final decisions about his life's work.
It is a profound testament to the fact that documentation isn't just, bureaucratic paperwork. Legal documentation is the ultimate form of continuing control.
Well said.
It is how you project your voice into a future where you can no longer physically speak.
Right. Because without the document, there's only silence. And as we've seen in the legal system, silence is immediately filled by the loudest, most expensive machinery imaginable.
I want to leave you with a final thought experiment drawn directly from a fascinating tease at the very end of our source material. We've spent this deep dive exploring the absolute chaos of leaving no instructions. But I want you to consider the opposite extreme.
Right, the other end of the legal spectrum.
Right. The source briefly mentions Aretha Franklin, the undisputed queen of soul. Now, when she died, she didn't leave a blank slate. She left wills. Multiple wills. Plural. Literally handwritten documents stuffed inside her couch cushions and locked in random cabinets throughout her home. Just conflicting, chaotic, deeply personal instructions hidden in the furniture.
Which is a whole different kind of nightmare.
So ask yourself this. As you think about your own legacy, your own fortress, is it worse to leave behind a total blank slate that the government coldly fills in for you using a sterile algorithm? Or is it worse to leave behind multiple conflicting versions of your final wishes, hidden in the cushions of your sofa, forcing your family to decipher and fight over your true intentions in court?
Wow.
What does it truly mean to speak for yourself when you're gone? Something to think about until our next deep dive.